Thank you for coming back up, Mr. Clayton. I have a few questions for you. I'd like you first to talk about, are you an attorney, by the way?
Yes, sir.
Okay, so can you talk about the Eighth Amendment to the U.S. Constitution and the constitutional protections for bail that exists in the state of California and how you may feel that this may violate those protections?
Thank you for the question. My issue here is this concept of least restrictive. And I think because bail is a third-party benefit, what we're doing is we're taking the focus away from the person's ties to the community, and we're looking at them purely as an individual. And I would argue that most people for whom bail is posted cannot themselves afford it. If we deny or reduce the level playing field of the availability of getting the third-party benefit in favor of what is state-funded unlimited conditions, we may run afoul of the Eighth Amendment. And that is what occurred in the lead-up to the change of the Maryland court rules and the Maryland Court of Appeals was this very argument. And it was enunciated by former U.S. Solicitor General Paul Clement, who's argued 85 cases before the U.S. Supreme Court, confident that this taking bail off a level playing field and putting it as a last resort would risk as-applied challenges under the Eighth Amendment. So I think that's a reality, and it's something worth considering. And I think the answer to that is leave it on a level playing field and let judges make the decisions in the appropriate cases.
Okay. The proponents have made a very good argument that a lot of people that don't have financial resources can, in fact, be stuck in jail. I assume that the industry would be interested in coming up with some type of a hybrid bail system that maybe will address their concerns about people that don't have the financial resources to bail out. But I'm also concerned about the people that do have resources, and I'd like to give some examples like my colleague from Santa Barbara, and I agree with many of her concerns about domestic violence. But let's talk about, sometimes in divorce cases, they get pretty ugly, and you may have one spouse accusing the other of child molestation, which is a very serious charge, has a very large bail amount. And this person may have a job, they have a reputation, and you could have bail as high as $1 million, and if they don't have $100,000 to come up with for bail, that person's stuck in jail, later potentially found innocent, lost his job, lost his house, maybe lost his, of course, his marriage is gone. Why shouldn't we allow him to have that opportunity to preserve his livelihood at the same time that he's presumed to be innocent until proven guilty? I see this as potentially devastating for those that have money, that have the ability to bail out. We're talking about equity. We're talking about people that don't have the resources. Well, let's try to fix that problem. But we shouldn't be taxing, if you will, or anti-taxing those that have the ability to get out, that firmly believe that they're innocent and have a lot at stake to lose if they don't get out.
Yeah, I'd agree with that. I think the problem, as I testified, is you're parking everybody in jail until this process can be done. And the bill says the risk assessment shall be done within blank period of time. Well, that is everyone's liberty, everyone in jail for that period of time. And I agree with you. We need to look at alternatives for the indigent. I'm negotiating with the Connecticut governor right now to try to create a privatized bail fund where bail agents can come in and allow for people to get released and provide accountability. So there are other alternatives, I think. But for us, I think, focusing on the true problem of indigency is what this legislation does not do. It focuses on a complete overhaul versus, I think, targeting what the specific problem is in the state of California.
Mr. Clayton, don't judges already have discretion at the bench to release anyone they feel is able to be released on their own recognizance, and probation certainly can do pre-trial release reports urging the judge to do the same. Does that not exist today?
Yeah, I mean, there's certainly exceptions, but yeah, judges have wide discretion now to release folks. They do take into considerations people's ability to pay, and certainly the bail schedules in California right now are too high, which I think delays release for a lot of people that'll ultimately get out on a lower bail.
Okay, just a couple more questions. Superior court judges are elected officials. Now, if I'm giving them the discretion to release somebody on their own recognizance, knowing that they have a high propensity to reoffend, I'm going to err on the side of keeping those people in jail. So while I've heard arguments that we're going to be emptying our jails out and creating capacity, I'm concerned that we're going to be actually keeping more people in jail rather than releasing people from jail. And I was curious to know what your feelings were on that.
You know, certainly I've heard that concern that the risk assessments are too conservative. Certainly the San Francisco public defender feels that way, or at least publicly has said that, even though I would presume he supports this legislation. But risk assessments can be conservative and can paint people as riskier than perhaps a judge would think. And so it could backfire. And certainly we've seen one county in Ohio, the risk assessment recommended remand of 52% of all defendants, and that would bankrupt everybody. And so there is certainly, that concern. And, we have to trust judges to try to get it right.
I want to just make an intervention. I appreciate that you asked the witness the question, but I wanted to raise the fact that this is an industry expressing an opinion on a judicial matter. So I just wanted to put it in the context.
That. Thank you. The proponent, one of the proponents of the bill said that the judges don't do any research or monitoring of perpetrators that go to a bail bondsman. But a bail bondsman has got a lot at stake in the process. They might get a 10% fee. But if they don't deliver that perpetrator to court in a timely way, they're responsible for 90% of that bond. Of course, they're backed up by a surety. And if they don't come up with that 90%, if the person doesn't come to the trial, and the bail bondsman's got to do a forfeiture, the county is the beneficiary of that money. Do you have any idea how much the state of California, or in particular the counties, receive every year from forfeitures?
No, that is correct. I was just talking about that last night. We probably need to get those numbers, but I don't know the answer to that. Certainly agents in California, I don't think they get 10%, and they have a huge, because the bails are so high, incentive to return these people. I'm working on 2 cases right now where we're trying to return sex offenders from Morocco, and it's hard. But without us, there would be no victim, or there would be no justice for any of these.
And then lastly, we heard that a majority of bail bond businesses are minority owned. I didn't know that. I was very astonished to hear that, and so if this bill were to pass as it is today, would a typical bail bonds business be able to survive? And if not, how many businesses in the state of California would be closed by virtue of this bill? How many people would be unemployed? And just one other thing, if there's no phase-in period for this bill, what do we do with the small business people, the minority-owned businesses that have long-term leases? Are they just expected to go bankrupt, or are we providing relief from them, from their leases that they're obligated to? Are we going to put all these minority business people out of business?
The answer to that is I don't know. I don't know how judges are going to behave. I think it will have a significant impact. It may trigger waves of consolidation. Certainly what we're seeing in New Jersey is who's left holding the bag on the liability that's out there when a business goes under, and that's happening in New Jersey. I mean, 4 bonds have been written all year. And so these businesses that have all these folks out on bail are filing for bankruptcy, and then what? Who goes to get them? So there's certainly concerns with that, and I think, going slow is probably the answer because of that.
Thank you for the answers to the questions. And I have one for Mr. Hertzberg, if I may. Senator Hertzberg, my friend, it's nice to see you as always. I would assume that as this bill progresses, that you'll be willing to work with the industry to consider a hybrid plan that accomplishes exactly what you're hoping for, and has to ensure that people that don't have the financial resources to bail out, that want that opportunity, might be able to achieve it in some way without taking away the possibility that somebody that has been accused of a serious crime, that has only money to pay bail to get out, to preserve their livelihoods. I hope that you'll be open to working with the opposition on that.